The views and opinions expressed on Coffee and Compatibility are those of the podcast host and do not necessarily reflect the official policy or position of ASHI.
Hey guys, welcome to another episode of Coffee and Compatibility. I'm Eric Weimer. With me, as always, is the mostly brilliant co-hosts, Dr. Kelly Hitchman and Jeremy Sherrill. How are you guys? I said mostly.
Good. Hi, everybody.
Hey, I'm doing great.
So, what's going on? Anything new happening for us? Have we got anything that we should particularly emphasize to our listeners?
Well, we do. We have to say a huge congratulations to our latest YouTube subscriber giveaway winner, who we'll be reaching out to directly to claim your prize on a free registration to the annual meeting. And I think we're not going to leave it at that, though. We're not going to leave it at that. Worry not, dear listener.
Oh.
We have stuff for you. We've come so far, we don't want to stop. So once we hit 600 subscribers, we'll be giving away another exclusive prize. So if you are not subscribed yet, head over to YouTube, head over to ASHI HLA on YouTube, subscribe. You'll be entered to win a prize in our next drawing. We're not going to stop. We're going to keep it going.
It's really fun. I just like that it's just so fun.
And we are at the point in the year where we are counting down the days to the 51st annual ASHI meeting. That is coming up in October in Orlando, Florida. Eric and Kelly, you're both going to be there, right?
I was thinking about attending.
I'll review my contract.
You're going to be there?
I'll review my contract.
Some things, a poster, a talk to.
I'll see what my agent says.
Well, early bird pricing for the ASHI meeting ends on September the 5th. So if you haven't already, you are going to want to go and register for the ASHI meeting before that early bird pricing ends. Again, that date is September the 5th. Also, if you are tuning in from a country with a low HDI score, you may qualify for up to 100% free registration. So discounted registration, even free registration is available depending on the country that you'd be traveling from. And so we will be thrilled to welcome the international community once again to the ASHI meeting this year. We hope to see you there.
Well, don't leave us yet, dear listener. We are on to today's guest. We're really excited about this one. Very different for the podcast. Today, we're joined by Dr. Kelly Parsons, who's the Director of Technology Commercialization at the University of North Carolina. Her insight is super important for our listeners who are researchers, inventors, innovators, anybody at all curious about the journey from the lab to the patent office. So we're going to talk all things tech transfer, legalese, licensing, and how to protect your intellectual property.
Renew your ASHI membership and continue accessing career-boosting benefits like certification opportunities, professional networking, and exclusive discounts on ASHI events. Stay informed, stay connected, and keep advancing your career in the HLA field. Don't miss out. Renew today at www.ashi-hla.org.
Today's guest on the podcast is Kelly Parsons. Kelly Parsons is the Director of Technology Commercialization at University of North Carolina, Chapel Hill, overseeing innovations in gene therapies and biologics. Since 2008, she has supported life science inventions across UNC, including vaccines, biologics, and research tools. And previously, she was a postdoctoral researcher studying lung immunology and an intern in the tech transfer office. She is a licensed patent agent and member of the Association of University Technology Managers and Licensing Executive Society. With all of those accolades, I almost feel bad asking, but may we call you Kelly?
Yes, please.
Oh gosh, thank you so much for being on the podcast today. This is so different than our normal wheelhouse. This is somewhere on a different continent than our normal wheelhouse, yet also very important. So I have a feeling that most of our listening audience, myself included, is not super familiar with this area. So your background is in research. You are an immunologist. So how did you get from research in lung immunology to patent and innovation?
Yeah, so I can give you the short story, I can give you the long story, but I'll start with at least the truncated version. And this might resonate particularly with folks who are still on the training end of things, who are listening to this podcast. But I love science. I went to grad school because I wanted to create impact, right? There were people in my life who, needed new therapies, needed hope. My best friend growing up was deaf, and she used to talk about when she was younger, like, one day I'm going to hear. One day they're going to be able to take care of this. And when she grew up, she had her children. Her daughter was born deaf as well. And so when they went in to do an assessment, the doctor looked at both of them and said, that you're both eligible for cochlear implants. And they had the surgery at the same time, around the same time. And so it was those kind of things of being excited about what science could actually do that inspired me. And so, I went to grad school, I think like most of us, thinking we were going to change the world, right? We were going to cure cancer, we were going to fix all the problems. And I think very quickly, you kind of get that knocked out of you, for better or for worse, that maybe I'm not going to solve all the things. I was pretty sure early on that I didn't see myself in a traditional faculty position, but I really loved the university. I was in love with science. And by the end of grad school, I kind of saw myself headed to law school, right? I really didn't necessarily see a path for myself at the bench, at the university. And then, at the nudging of my husband to be, he was like, how about you get a job? Right. And so at that point I thought, well, a postdoc's close enough, right? I'll go do a postdoc. And so I came to UNC in 2006 as a postdoc. And at the time I started sniffing around, like every opportunity I could find to learn about careers or opportunities. And I remember distinctly, like it was yesterday, I went to a intellectual property panel. And there was a patent attorney and there was a tech transfer officer on the panel. And they started talking about, who has the better job, right? So, in jest, it started off silly, right? The patent attorney was like, well, I make more money than you do. And the tech transfer officer was like, well, I send you all of my work on Friday at 5 p.m. and I go home, right? But then they really started talking about what they did. And the tech transfer officer said, my job is to make sure that all of the amazing things that are happening in our labs at the universities actually help somebody and actually move outside of the lab, outside of a publication, and make their way to society, to a patient, economic development. And that was my light bulb moment. So I literally walked across campus to the tech transfer office and begged for them to let me work for free. And so, so I started interning in the office in fall of 07. And spring of the next year, I came on full time. So the rest was history. So that's my story.
Now, Kelly, what types of intellectual property are really considered patentable, right? Are we talking about just tangible products? Are we talking about processes in science, right? We're presumably talking about new types of assays. What other types of intellectual property qualify?
Yeah, so I mean, you think about any kind of, methods of manufacture, processes, compositions. So I mean, we could sit here all day and name off things that could be patentable, right? So if we're thinking in the life science space, we could be thinking about, obviously new small molecules, right? New biologics, monoclonal antibodies. We could talk about peptide therapeutics. Obviously, oncology right now, CAR T is huge. We could be talking about, we'd have a lot of this at UNC, new microfluidic devices, right, that allow you to do research faster and cheaper. One of our companies actually that's done very well is a company that's made handheld mass spec devices, right, which can be used to detect drugs at a crime scene or to do, evaluations on site. So it could be that, it could be, different types of research materials. So, if you can modify something in a way that improves either its activity, how helpful it is, it generates a new effect, a new assay, a lot of those things will fall under the patent system.
So what you're saying is our executive producer should absolutely patent this logo because
Well, that would be a trademark, but that's a whole different
Oh, see, I'm
different
glad I
beast,
asked. Well,
right?
okay, so this actually, I'm so glad you said that because not being familiar with this area, and I feel silly for doing so. Now I know because he is an innovator, I know that Eric Weimer has used your services because he's a smart guy. And all of us probably should have at some point used your services because we've all got, especially in the HLA space, everything's very niche. We all do everything our own way. We could patent processes, center specific protocols, all kinds of things.
Mm-hmm.
My question is, because I don't really know if I'm part of an institution and I develop an assay or a protocol and I want to patent that and I come to your office, who owns that patent? Me or the institution? Or a little of both?
So the institution would own it, right? So it's no different than if you go out and get a job in a pharmaceutical company or, a CDMO or any kind of other company, right? If you're doing your job and an invention comes out of the creation of your job, then it's owned by your employer, right? But what I like to tell people is that there's some perks to inventing inside of an academic institution. So, for instance, I had a former colleague whose father was an inventor on one of the early iPhone patents. My understanding is he got a watch as a thank you for his time and effort. At a university, under Bayh-Dole legislation, which covers the transfer of ownership of IP to universities for federally funded inventions, part of those requirements is that we have to personally incentivize inventors. And while those percentages are different at every institution, at least at UNC, our inventors receive 40% of our revenue after our expenses. So if you come to us with a great idea, it's something that we think has, commercial potential, we patent that, and obviously the university is the one who's going to cover those costs, right? So our office is going to cover the cost of the patenting. We're going to reach out, look for potential partners. We find a licensee. We do a deal with that company, and now the company is selling product and there's money coming in. We're going to cut personal checks for 40% of that revenue back to the inventors related to that invention. So it's, it's not even like the institutions are coming in and like ripping inventions out of people's arms. It's more of, we're going to circle up. The university is going to put in a lot of resources, time, effort. And if this goes well, you're going to join us in reaping the benefit.
And I mean, that's something I think that is poorly understood across the spectrum, right? Is
Yeah.
the shared model that academic institutions have and in there. I mean, I think something that has come up, I think in various classes and with you and other entities is, how do you patent say like a diagnostic assay, right? So a lot of our listeners are medical lab scientists who work in clinical labs and perform assays that Dr. Hitchman has already alluded to, like perform modifications. They've done this and that is sort of unique, if you will, to make them, we'll just say, better.
Yeah.
And like how do you approach or think about things along those lines?
So I think there's actually multiple questions layered into that. And I guess I'm going to start maybe not directly where your question sat, but I think something important to think about. So, from our perspective, when we're evaluating something that you bring in the door, it is not an evaluation of how many dollars could we get off of this, right? In fact, most tech transfer offices around the country lose money. This is a service effort. Most institutions that are making a lot of money off of this work have one or two inventions that are pretty much the main revenue stream for the entire office, right? So when you come to us with that great idea or that new diagnostic assay, what we're thinking about is what is the potential impact for this invention and what is the best way to make it accessible, right? So would patenting help get this available to patients who may need it, right? And, this is one area where patent law and some of court rulings have made the space, particularly on diagnostics, really, really messy. So Eric, I know we've chatted about this before. There were a couple of rulings in 2012, 2013 around different diagnostic tests that started to call into question whether or not these were patentable. And I know, at least for us, what we saw were after those rulings and after there became a lot of gray space around what was going to be patentable in the diagnostic field, a lot of our licensees who were developing assays out of UNC went running for the hills, right? I mean, there was kind of this mass kind of dumping of licenses and dumping of projects and saying, look, if we can't get patents on this, then we're not going to invest the money to take this through, FDA approval if it was an assay that needed such. And so, where we've kind of been struggling for a while, and now there is some legislation on the table called PARA, so the Patent Eligibility Restoration Act, that talks about, resetting what is patentable under the law. We have struggled around partnering and developing diagnostic assays. And so, I understand this is very complex. I understand that there are pros and cons for why some of these things should or should not be patentable. But for us, if the goal is making these things available to patients, and frankly, like it or not, we live in the system that we live in with medical care, getting assays validated and FDA approved, so hopefully patients' insurance plans are going to cover them. And so, that is kind of the swirl and battle that we've been in now for well over a decade in this particular area.
Now, Kelly, I know we're going to have follow-up questions about that legislation because that is really, really interesting. But before we dive any further into that, I'm really curious, how does publishing or presenting at conferences impact your ability to patent down the line?
So in the US, there is a 1-year grace period, right? So if you are to, let's say, present at a conference or publish a manuscript, or frankly, just go meet with a company and share your ideas, you have 1 year to get on file with the USPTO. However, that is only true in the US. Everywhere else in the world, the second that you put that idea out there, you've effectively gifted it to the public, right? And, to be frank, in the diagnostic field, often we see more protection localized to the US, right? So we're not as concerned about international rights in that case because we're just looking for approval and validation in the US to kind of get it adopted. But particularly if you're looking at small molecules, gene therapies, monoclonals, where you may really want to have rights in other major markets like Europe, giving that up and presenting before you file the patent application can really damage your ability to move that asset forward. So, we tell people, and I would tell this to everybody, no matter where you're at, your tech transfer office would rather talk to you too early than too late. So even if you just are thinking about an idea and you just want to kick around what it might look like to try to translate your idea into something tangible, go have that conversation. We all get the Friday afternoon phone calls that someone's getting on a plane on Saturday to go present in Europe on Monday. We deal with it, but it's definitely not our preferred route. So earlier, better than later.
And real quick, just for everyone listening, you referenced there getting on file with the USPTO. The USPTO there is
The United States Patent and Trademark Office.
perfect. That was going to be my guess, but
Yes, and another misconception that we have people coming to us all the time thinking that somehow reporting it to their tech transfer office counts as protection. It is not. Telling me about it does not provide you legal protections. I mean, we have to actually have time to get a patent application on file.
Yeah, I mean, I think you mentioned some of the current legislation that's going through some form of Congress.
Yep.
I wonder if you can touch on sort of, given your expertise, your perspective on how it fits in. Is it good? Is it bad? Like, what is your read of the current state?
Yeah, I mean, I know folks in my field are generally pretty excited about it. Doesn't mean it will actually get passed. But particularly if you look back at, the Myriad ruling in 2013, that one was around, Myriad identifying in particular where BRCA1 and BRCA2 were located on that gene, and then building clinical assays around it. And, that is complex because, in those cases, it was a little bit more limited to that particular gene sequence. If you go back to the 1980s, 1990s, folks were actually filing and getting patents issued on human genes, right? I've identified gene X, I've patented it. If you target it with a drug, you're infringing, right? That's not what we're talking about going back to under this legislation. And I think there is some fear that that's where we're resetting the bar to. The bigger issue is around situations where let's say that we've identified a particular protein that fluctuates, let's say with cancer. So for instance, there are several diagnostics now that I know are being researched on our ability to identify really, really early cancers before imaging could even detect it, right? So if I can identify what that protein is, what level, then I could develop an assay that we could easily use to screen folks for cancers at an exceedingly early stage. Well, under some of these early rulings, the fact that you are measuring the level of a naturally fluctuating protein, it would be considered patent ineligible, right? And where this para legislation is going is saying, look, by isolating this gene out of the human body in order to run this assay, that you've now made it patent eligible again, so that you could protect, a method and an assay around the use of now identifying what these trends are related to some particular outcome you're trying to measure.
I kind of get the feeling I'm learning so much from this call, as I hope our listeners are as well. I kind of get the feeling that I'm sure it doesn't feel this way for you, but that your office is an underutilized resource. And so if you, in these parting few minutes that we have, had some advice in the climate that we're in, innovative science, fast evolving technology, and especially institution of AI.
Yeah.
What would you say to people who are kind of working in any type of clinical science space? Should they be really considering this for just about any process they're developing? And should AI, given I guess both sides of that, like generating AI tools, but then also the potential for AI to usurp or scoop tools, should we be utilizing your services more frequently, and how can folks more easily go about that, get more information?
Yeah, I mean, I think, you brought up AI. I think that's a whole nother podcast, right? Around, especially even AI and patenting, because the courts are already starting to weigh in. I think it's going to be really interesting to watch this play out over the next 5 to 10 years. Once again, I think that there's often this misperception that, tech transfer offices are set up from a painfully commercial minded point of view, that what we care about is how much money we can make. We care about kind of walling things off. And that couldn't be further from the truth, right? We're trying to think about, is there something we can do to help you advance the research? Is there something we can do to make this more accessible? And, that's not always patenting, right? I mean, there are cases when we're saying, look, patenting here is probably not the best course of action, right? Maybe this is something we should make available. Or in the case of research tools, we don't really need exclusivity. So a lot of times we don't patent those. We just license the tangible material to different companies who want to utilize them in their programs. So I guess what I would say is, if you have any thought about this, or you have thought about just translating your idea or your work into kind of either startup companies or real life products or services, go have those conversations. Because your tech transfer office can give you a lot of advice on what you may or may not want to do.
Kelly, well, thank you very much for your time today. There are so many other questions that I'm sure we all have for you. So, be on the lookout. You may be asked to do version 2.0 of this. So, thank you very much for the time.
You're welcome. Thank you, guys.
Welcome back, everybody, to the TEAT, where we answer questions from our listeners. Today's question is very interesting, and I agree with this listener. This anonymous listener says, I recently went to the World Transplant Congress, and as people were presenting some of what is unpublished data, I noticed in almost every publication presentation or non-publication presentation, people pulling out their phones and taking pictures of slides. With so many researchers and clinicians presenting and giving this data pre-publication, do you think enough attention is being paid to protecting the data in presentation or prior to publication via patents before they go public? And I think that is a fantastic question. I probably don't have the best answer to that question. I know as a person who presents at those meetings and will present unpublished data that I worry about that, especially because in most meetings, you do say, by presenting in this meeting, I give you the right to share my slides, right? So I absolutely have concerns about that. Have I ever gone out, though, and patented my work or always been able to publish my work before I give those presentations? No. Eric, I think you have a unique perspective here because you have utilized your patent office relative to publications and presentations. So what do you think about this question?
No, it's a really good question because, I don't think in any of these cases we're looking to stifle innovation or stifle anyone's ability to go and present, right? It's important for the spread of science. It's important for the individuals, right? My experience has been that as long as you reach out to sort of the relevant, division, department, or whatever at your institution, like a tech transfer office, they will give you pretty solid advice on what to follow. And it typically, as long as, you have submitted and had conversations with them beforehand, they will ensure any of the intellectual property protections so that when you present and someone takes out their phone and video records the entire thing, right, the intellectual property is still protected. And that's what gives the ability for institutions to prohibit the use of, right? Having a patent doesn't mean you can do something. It means you can prohibit others from doing something. And so, they can do that. And as long as it's been submitted to the patent and trademark offices before you do that, that usually grants the protections you need.
I'm so glad you have experience in that area, because not only do I know I can reach out to you if I have these questions, but our audience can too. And audience, don't forget, if you need career advice or have a question about something happening in your lab, visit our podcast page at ashi-hla.org/page/Ashi podcast, or you can email us at info@ashi-hla.org with the TEA in the subject line.
Hey there, Coffee and Compatibility listeners. Do you have a technologist that you'd like to spotlight? Nominate them by sharing their story with us. Email us at info@ashi-hla.org for a chance to feature them in an upcoming episode of Coffee and Compatibility. Don't go anywhere. We'll be back in just a few moments to recap our thoughts on today's episode.
Wow, all of this is fascinating. And audience, so we were just having like a little between segment chat. Fun fact, because I'm sure somebody will ask you, Jeremy Sherrill almost was a patent attorney instead of working in HLA, and we snagged him instead of the patent office. So
it was a close shave.
Fun fact.
Well, I mean, and what's crazier is she and I got the exact same advice. Like her ex-husband told her, "How about you get a job?" My parents said the same thing to me after I graduated college, like, get a job. And so, you know,
I think all of the folks listening, if there are any listening that did the postdoc thing, which I know Dr. Weimer, you did, I did, like, that is the funniest response to get a job, because it is like 10 times what like a normal job is for 10 times less pay. It is kind of a job. So probably like
Sounds
she
great.
still, regardless of that advice, like did her own thing. I love it.
And I mean, it's such a fascinating thing that I think people in our community don't often like touch on, right? Like, not only are we busy every day, like doing the regular patient care that we always do, but, you know, so many of the things we do touch on, you know, modifications of this, changes of that, new ways of evaluating this, right? And they are new ways. And because they are ways that often make an existing process better, it's at least an opportunity to be had with your respective tech transfer sort of divisions, if you will. And as she said, definitely talk to them early. They will give you advice.
Yeah. How often did you utilize their office, Eric? Like, tell us a little bit about your experience as a user. Because that's something we didn't get to touch on much, but you were colleagues.
Yeah, I've known Dr. Parsons for a while. We actually went to grad school together. And I reached out to her office many, many years ago, but it was super late in the like science development process. Like, I had already done a number of things there. And then I think the first time I had actually given a presentation at Ashi about some of the work my group had done, and then talked to them. And you see the order of events here. And so they definitely gave me the slap on the wrist for talking to them after having presented. And I will tell you, she is not lying, that if you do it in the incorrect order, you will lose rights overseas, particularly in Europe, for things that you patent or and whatnot. And so that's why it's better. Like, so the lesson I learned, and I think that's an important takeaway, is if you think you're doing something that may be of value in that regard, just ask. I've asked them plenty of times, and they'll be like, "You're not ready yet. Like, whatever you have right now, it's great, it's awesome. You're not ready yet." If it is ready, they will work with you typically to ensure that the patent side is secure, while maintaining your ability to publish, if that's something you want to do and concerned with. They have worked with us a number of times in that regard. So it's just an underutilized position at many, many academic centers.
This was a really interesting episode, just not being at in a university setting. I was totally unaware that this type of position or this type of department existed, and maybe good information, especially for those listeners who are at academic or university settings.
There's so much we didn't get to touch on, right? I mean, we didn't really touch on at all of the deep into some of the newer legislation that she sort of scratched on, and then the sort of elephant or whale, which is larger? A whale? Whale's got to be larger. In the room, right, of artificial intelligence and its impact on all of the things. So we may need to get Dr. Parsons to come back.
Yeah, listeners, let us know if you want an AI patent law episode. I want that episode.
I do. Awesome. Well, thank you guys for listening. Until next time. Bye.